I'll give you a hypo, Mr. Roper. Suppose there's an airline crash of some kind, and somebody brings a lawsuit. It's a private airline, and somebody brings a lawsuit and says there's a defective part. And the airplane manufacturing company says, this part that you're talking about, it also goes into all the airplanes that we make for the federal government, which is a very substantial part of our business. So if you enjoin us from using this part, it's really going to affect the federal government. Does that mean that that suit, which is a standard state tort suit, should be removed?
And I assume there that the remedy is just for damages and not actually for an injunction against production of the part. In that case, I would say no, that is not removable, because, effectively what that remedy is asking for is the equivalent of an injunction against the use of the part in civilian planes. Of course, if they came in and said—
But if they're just asking for damages, which would effectively prevent, it's like, oh my gosh, if we're going to be subject to damages here, we've better find another part. So that would affect the way that the federal government is going to, maybe the federal government even asked for this part.
I don't think that affects it in the relevant sense, because the measure of damages in that case is presumably pegged to the use of the part in the civilian plane. Of course, if they came in and said state law permits us to get a universal injunction against the production of this part for anyone ever, that we would have much greater concerns about, because that would actually be impeding the federal government's conduct. But just a normal state law damages action for purely civilian conduct, no.
What does it mean to have a colorable federal defense?
So this court's cases haven't fully explored that question. It's definitely something above frivolous. It seems to be, as we read the cases, a little bit more than that. But the basic gist of the cases as we take it is that when the defendant's story is that they were doing this because the federal government told them to do so, that should be a question that should ultimately be resolved in federal court.
One of the issues here, right, is that each of the three parts of this, you can always say, oh, well, that it'll be taken care of by the other prong of the test, but each of the three prongs is setting a really low bar, including the federal defense prong. It's not like you have to have a federal defense. You have to have a colorable federal defense, which is just barely above frivolous.
Yes, and I think that that is intentional. When you think about this statute against the backdrop of Congress's authority under Article 3 to put every federal defense in federal court, and so Congress has created this exception to the well-pleaded complaint rule, and it has identified this subset of cases that most directly implicate the federal government. And we don't want that to be an extraordinarily high bar, because again, as Mr. Clement said, all we are talking about here is a forum, and when the defendant has a plausible story that the federal government told them to do this, that is a story we ultimately want to be resolved by a federal judge in federal court. In the context of this case, I don't think it casts any aspersions on the good people of Plaquemines Parish to say that when we're talking about liability for conduct the federal government directed during World War II, that is a question that should be resolved in federal court.